this is People of the State of Michigan versus Devin Halsey, docket number 20-685FH. This is the time set for sentencing in this matter. And before I go one step further, Mr. Halsey, is that how you say it? Halsey?
Yes. Yes, Your Honor.
Can you confirm for me that you're okay with doing a remote sentencing like this? Because I do need your consent in order to do that.
I am okay with it, Your Honor.
Thank you. Mr. Halsey, you were convicted of aggravated stalking. That is a felony punishable by up to 5 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Feigelson. And Mr. Feigelson, have you had a chance to go through the pre-sentence report with your client?
I have, Your Honor.
Do you have any additions, deletions, or corrections?
Just one, Your Honor. My last name was spelled I-E, and it should be E-I. It's on the first page under attorney, and on page 4 of the report in the first paragraph of the evaluation and plan.
Okay, I changed that. It's not as bad as my name was in the district court transcript, but you should have your name spelled correctly, so I've got that.
And I think one other thing that's not in there in that same sentence, that I work at the public defender's office and that we were appointed to represent him, for clarity, Your Honor.
With the public defender's office. Okay. Anything else?
I do not have any other changes to the body of the report, Your Honor.
Any objection to the scoring of the guidelines?
I think both the defense and the people had an agreement on the changes. I'll let Ms. Allen put that on the record, Your Honor.
Okay, Ms. Allen?
Thank you, Your Honor. OV 13 is should be scored at 0. And that changes the total OVs to 25, the level to a 3, and the range to 0 to 17.
0 to 17, you said?
Yes, Your Honor.
Okay. So I have made all of those changes, so it's a C3 range of 0 to 17. I acknowledge there's a Killebrew agreement of no upfront jail. Did the people have any other corrections to anything?
No, Your Honor.
All right. And there's a victim, is that right, who wishes to be heard?
Yes, Your Honor. Ms. Walsh has joined us by Zoom, and I believe she has a statement to make to the court as well.
Okay, so this is Molly Walsh, for the record, and if you want to, there you go, unmute yourself, and go ahead, Ms. Walsh, whenever you're ready.
Okay, thank you so much for giving me time to speak today, Your Honor. I did prepare a statement, and to start, we do have a child together. He is now 17 months old, and we both want to do our best to co-parent for him. Devin, even though we haven't been able to communicate or be with each other, he's been able to take Phoenix to school through a third party on days when I wasn't able to. And when we started our process, it's been a long journey. We started 3 years ago being together in a relationship, and it was a pretty rough start, being that we both needed so much help with drug dependency, violence, domestic violence, and therapy. But we did those classes. We independently took we took anger management, we took tons of classes, substance abuse. I took a lot of domestic violence classes and therapy myself. We did go to some together. And I wasn't very confident that these classes would actually help us. I didn't expect to see any real change. At the time I was pregnant, and I didn't see a future where he would be involved with my son. But it has actually incredibly helped us. I'm really proud to say that I don't feel either of us are drug dependent at all, which is what our violence this last time around was about. I was accusing him of selling drugs, and he was not doing that. The police knew when they showed up, and they said we didn't need a CPS case. I really pressured and asked for the CPS case. So for the last 6 months, I've worked with Bob Siegel, and he did just close our case. And he recommended that me and Devin attend some more therapy sessions. We haven't done any together in over a year now. And he recommended Miss Heather from Highfields, and we've been communicating over email. She did say we could meet on the 2nd, December 2nd at 1 p.m. over Zoom. And then we could discuss doing in-person appointments, over Zoom appointments. I would like, and I would greatly appreciate, for the best interest of my family, myself, and my son, and Devin, if we could have permission to do those therapy classes together. There's no excuse for us to be violent with each other. Our biggest difficulty was getting past the drugs. Now it's getting past the violence and the cycle that we were stuck in. I do have PTSD from a time when I was 16 and I was kidnapped. So we both have mental issues that we need support with. And Devin has been an incredible support with me through my PTSD struggle. Losing him has been very hard for me. Pushing him away is a habit. And I'm really sorry for falsely accusing him, for crashing his car, and for really instigating this fight to start. Now, as soon as Devin left, it was made apparent that my neighbors were the ones selling drugs. I have a shared driveway. I have a PPO against a few of the people there in that house now. As soon as Devin was out of my house, I smoked weed with them. I shared my weed, and they then tried to sell me coke and solicit sex from me, at which point when I refused, they killed my cat. They filmed their dog eating my kitten because they didn't want me to report it. And there's not enough proof that I can show, even having witnessed the white baggie handing off in my driveway with my 1-year-old. I'm so sorry, I'm crying. With my 1-year-old in my arms, returning from our walk to the park, seeing them sell the drugs right in front of us. Proudly. And then they pointed guns at my 1-year-old son also. These are people who live next door to me. Our walls are fairly thin, and during mine and Devin's fights, they would yell things. Even when I changed my 1-year-old's diaper, they yell, "Hit her." They yell obscene things that really messed with us. Now I am moving. I got Section 8, and I plan to move to Edgewood Townhomes. If the process follows, I'm looking at a couple properties, but that is the goal, to be moved out in the next 2 months now. And I am also sorry, Devin, for having you and asking you to be in this environment, and then trusting my neighbors at the time. They mowed my lawn, they were helpful. When Devin lived with me, I didn't know they were selling drugs. I thought they were good people, and I trusted them more than I trusted you, Devin, and I'm really sorry for that. Let me make sure that's everything. The last thing I'd like to note is that Devin has been supportive of our child's emotional growth with many father and son video calls. He would call and read to him Harry Potter, Beatrix Potter children's story classics. Even occasionally he would read from the Bible, and they would have a really strong bonding relationship that was, for the most part, very healthy and very educational. There's definitely room for both of us to improve on our parenting skills. And I hope that if we're both willing to cooperate and learn a better process to parent together, that would best serve my son and both of us. And that completes my statement.
All right, thank you. Ms. Allen, did the people wish to be heard?
Only to say, Your Honor, when this happened in district court, when the plea was entered, the prosecutor down there at the time did speak with Ms. Walsh about a lot of these circumstances, which is how the plea agreement came to be made in district court. And that I understand where she's coming from on a lot of these issues, because this is what happens in the context of a domestic violence situation where you have a shared child, you have, that person's going to be in your life and she wants to work through it to the best possible. Obviously, I have concerns because this stems from a PPO that was in place and he decided to violate it. And that's the conviction that we have, but that there's an order in place that when he decided he did not want to follow, he did not. And it was in the context where their child was there. And as much progress as we want to make forward, which I think can be good for the things he has done to make himself better, I still have a lot of concerns about making sure everybody is safe and that it's done in a safe way and not on his terms, but on the court's terms and on through probation, so that we can safely, if there's a way to move forward and let him co-parent, do it, but not to the extent where he's in charge, because it's shown that that's not something that he hasn't followed other court orders. So if it can be done, I'd like it to be done in a safe way, and they can work with his probation agent to allow for those kind of safe interactions to happen when they're required.
All right, thank you. Mr. Feigelson, I'll hear from you.
Yes, Your Honor, thank you. We're supportive of the recommendations adopted by probation. Listening to Ms. Walsh speak, we are supportive of attending counseling. Obviously, the concerns would be the PPO and all the other history of the violence, but if it's going to be over Zoom, Your Honor, they're not going to be together, and it might be helpful to have them work not only through their issues together as a couple, but help them, because they're going to have to deal with each other for their child over the next 18 years. So to work through some of these issues would be helpful. And we'd be supportive of going to the therapy sessions via Zoom, Your Honor, assuming probation could be involved to monitor those things, Your Honor. If I made a poor decision, I think his confusion was he didn't go over there with any intent to have any problems with her, but obviously when the PPO order means he can't have any contact with her at all, Your Honor, and I think that was confusion on his part. He realizes now that that was a poor decision and a poor choice. He's willing to take the steps necessary on probation to learn from those things, Your Honor, and we would ask that the probation recommendations be followed. Thank you, Your Honor.
All right, thank you. And Mr. Halsey, is there anything you wish to say?
I really just want to be able to co-parent to the best of my abilities to where we can eventually be together. And even if we don't end up being together, to at least be able to co-parent healthy.
Okay. Thank you. Well, first of all, I completely understand Ms. Walsh's feelings, and I acknowledge them, and I understand why she wants to go where she wants to go with all of this. But I play a different role, obviously, than Ms. Walsh does, and I'm not quite as forgiving about this situation. This was unwanted contact that was whatever the situation was that came before it was bad enough that Ms. Walsh went to court and got a PPO, and there was a court order as a result of that saying no contact with her. And you just violated it and did it in a way that constituted stalking, and that it obviously caused her emotional anguish and made her feel harassed because of the repeated contacts, and then at least one following the institution of the PPO. So she even said, and maybe this report, maybe the statement from Ms. Walsh at the time that's in the pre-sentence report, maybe it was taken back at the inception of this case, but she feared that you were homicidal. So, I'm going to take this a lot more seriously than someone who is in the center of it and has a child with you and has hopes for that child and wants to co-parent, which I give her credit for all of that. But I'm looking at it through a different lens. So, you know, there's a reason that we tell people when they're on probation and there is a victim that they can't have contact with the victim of any kind. And that includes direct, indirect, through a third person, through letters, through emails, through texts. There's a reason for that. And that is that you don't have to be in person with someone to fire up those emotions and trigger something that causes you to act in a way that is contrary to law and puts someone else at risk. So I'm not saying that Ms. Walsh's desires will never come true as far as co-parenting and even counseling together. But I agree with what the prosecutor said. It's going to have to be on the terms of the court this time and not on your terms solely, Mr. Halsey. So the terms of the court typically on cases like this are that you have to have some probation under your belt first. And one of the most concerning, or one of the biggest landmarks will be completing some kind of behavior intervention programming, which is recommended and will be ordered for you on probation. Then I consult with the probation agent who's supervising you, and we go from there. But that's going to be the course of events here. So I am going to place you on probation for 60 months, 67 days in jail with credit for 67 days served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $600 payable at the rate of $10 a month, costs in the amount of $500 based on the State Court Administrative Office calculated average cost for criminal case in Ingham County. Additional conditions of probation are no use or possession of alcoholic beverages, controlled substances, drug paraphernalia, or medical marijuana. Comply with both drug and alcohol testing as your agent directs. You must complete a substance abuse assessment if your agent refers you to that, and then complete any outpatient or residential substance abuse treatment that's recommended. You must complete a batterer intervention or domestic violence program at a qualified community-based service provider. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You cannot possess a weapon while you're on probation. You must comply with all the written and verbal orders of your agent. Let the agent into your home at any time. Submit to a search of your person or property without need of a warrant. Report any changes to your agent within 24 hours. No verbal, written, electronic, or in-person contact with Molly Walsh, either directly or through another person. You may not be within 500 feet of her residence, school, or place of employment. And your supervision may transfer to Oakland County if that's where you're living. Mr. Halsey, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. It explains that more on a form that we will mail to you. It's just important that you know that for the appeal, the time starts running from today. And then the other thing you need to know is that you'll need to be in touch with the probation department within 24 hours of right now in order to touch base with them and get your probation orientation and get everything in place. So you should contact adult probation here in Ingham County, even though you will be transferred probably, but start here and contact them in Ingham County. You can do that via phone. They're not seeing people in person. And just make sure you do that within 24 hours. Do you have any questions?
No. Oh,
Okay.
I'm sorry.
That's okay.
I was wondering if am I able to go get my tether taken off right after this?
Oh yeah, that's only pre-sentencing. So once you're sentenced, the bond conditions no longer apply. So the tether does come off.
Okay.
Okay,
All
good
right.
luck. You're all set.
All right.
Thank you
Very much.
Wait, I have a question. Concerning the the first part of what the sentencing is. Could you repeat that? The 60 months probation, $600. Is that $600 for these 5 years?
Yes, $600 is this supervision fee that's required by law.
Okay, but it's not
And
like
it's-
$600 a month, right?
No. It's payable at $10 a month. The probation department takes care of that.
And then can I ask you, would there be any additional fees? And I'm asking because I am a little bit, my son is financially dependent on some things with Devin. I don't have a car, so things, I need to know that he can be stable and he's not gonna have to pay, like this tether was a huge expense.
Right, the tether's done, and I already stated what all the fees are. Most of them are required by law, and I can't waive them or reduce them.
Okay, and
Alright.
what was that?
I can answer your questions too, Molly. Why don't you email me your questions and I'll answer them too, okay? I have all the documents, okay?
Thank you so much.
Yeah, I'm
Thank
happy,
you.
I can answer them for you.
Thank you, Your Honor. Have a good day.
Thank you. Okay, let's see, who all do I need here? Mr. Roper is here with counsel. Kerry Teetsor is here via Zoom. I'll let him in. Mr. Woodcoker is the AG. I'll let him in. It's hard to keep track of. I guess that's it. Okay, we have two matters actually this afternoon from Mr. Roper. And I'll first do the sentencing on docket number 20-601 FH. And on that file, Mr. Roper, you were convicted of possession of methamphetamine, and that is, of course, a felony punishable by up to 10 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Sturdivant. Mr. Sturdivant, have you had a chance to go through the pre-sentence report with your client?
Yes, Your Honor, we've reviewed the pre-sentence report. We just have some minor corrections to the family and marriage section.
Okay, that would be like near the end then?
Yes. The names of the family members.
Oh, on the previous, they used the previous pre, right?
Yeah, I think it's one, both for the same.
Yeah, okay, family, go ahead.
Yep. So instead of Kirk Megidson, or Keith Megidson, it should be Kirk. So K-I-R-K.
Okay,
No, it shouldn't be, it should be Kirk Megidson instead of Legginson, or Leggins, whatever that says.
Oh, okay, I'm sorry.
Keith and Kirk are twins.
I'm mistaking
Okay.
your notes here. So where it says Kirk Leggins, instead it should say Kirk Megidson, like the name above it. And then for Miss Lockhart, or where it says Michelle Flowchart, I think it should be Lockhart.
Yes, and it's Bechel. It's a mix between my father and mother's.
So Beschelle.
wait a minute, give me that again. I was still working on flow
Oh,
chart.
no, no problem. B is in boy,
Yes.
E is in Edward, Schelle.
Okay, and then the last name is Lockhart,
Correct.
Lockhart.
Yes.
Got it?
And then next one's a bit easier. It should be Talia Richardson, so just add the A.
Got it.
And then instead of Keno Vanilla, it should be Keowa, Keowa.
It's pronounced Kiowa.
Kiowa, so my
Kiowa
mistake.
Bonilla.
Bonilla, Bonilla.
Okay,
And then after that one, how do you,
That's Kier.
so Kier Blair, so it should be Kyre instead of Lyre.
boy, those got massacred, didn't they?
Okay, and then, we're not done quite yet. We have the children, below that under the marriage section. Instead of Amarillo, it should be Amari, Amari.
Okay,
Instead of Lyre, it should be Lyric, Lyric.
okay,
Instead of the, it should be
Taj.
Taj, Tahje.
okay.
I think the bottom two are fine.
Uh,
Sakai's right, and then Yolani's.
Yep, and that takes care of it.
Okay,
So other than those corrections, we have no additions, corrections, or deletions to the report.
all right. And any objection to the scoring of the guidelines?
None, Your Honor, thank you.
Did the people have any corrections to the report or objections to scoring?
No, Your Honor, thank you.
And did the people wish to be heard?
No, Your Honor, thank you.
All right, then Mr. Sturdivant?
Thank you, Your Honor. I would ask that the court follow the recommendation of probation, which I believe is for Mr. Roper to not serve any upfront jail on this file and continue with his outpatient treatment that he voluntarily signed up for and is doing well with at Crystal Ray. I believe the court has been provided a copy of a letter from that. He also had submitted a copy of a letter from his employer indicating that he's doing well and earning a good living at this time. I think it means a lot that Mr. Roper went out voluntarily without a court order and got himself in treatment, because I think he understands full well that he has a substance abuse problem and he needs to take care of it, because not only is it leading to criminal charges that are very serious where he could, potentially do prison time if, the circumstances were different. And not only is it affecting that, but it's also affecting this other case that obviously we're here for, and his ability to ensure that his child support is taken care of. So for those reasons, I ask the court follow the recommendation of probation on this file.
Okay, and Mr. Roper, anything you would like to say?
I would just like to say that I'm in hindsight, I'm thankful for what I've had to go through, and getting back in treatment has been a blessing, and I like getting up to work. It keeps me structured, and I've been on a good pace, and getting in this building and getting out of work in time to get in this building and pay some child support has been a problem, but I put as much as I could afford to on it today, try to help my case, and I just look forward to keeping up with my recovery, because it's been going good, and my job's been going good as well. So.
Okay. Well, you can't see it, but I'm smiling at you behind
Okay.
the mask because I'm really impressed with how well you've been doing at Crystal Ray, and I'm very happy for you. You're
Good.
doing a great job.
Thank you.
And that was a pretty nice letter that they wrote about your progress, and I'm extremely proud of you and happy for you, and I want you to just keep working at it, I mean, I've sentenced a lot of people with, substance use disorder, no question about it. One guy, he just stuck in my head, I'm like, what happened? Because he had been good, and then all of a sudden he uses, and he said, for one day I forgot I was an addict. And, it just really drove home for me, because I've never experienced this, but it drove home to me that, it's like a job that you have to keep working at, and you can't ever just let it go or backslide or get lazy or, pretend it isn't there, because it is. But I think you can do it. I mean, you're obviously a strong individual to have done what you've already done. I am going to place you on probation for a period of 18 months and 1 day in the Ingham County Jail with credit for 1 day served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $180, payable at the rate of $10 a month. Cost in the amount of $250, which is a big reduction from the State Court Administrative Office calculated average cost of a criminal case in Ingham County. Additional conditions of probation are the ones you might expect. No use or possession of alcoholic beverages, controlled substances, drug paraphernalia, medical marijuana, comply with both drug and alcohol testing as your agent directs, complete a substance abuse treatment, or complete a whatever outpatient or residential substance abuse treatment is recommended for you. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You may not change your address unless you first, your residence, unless you first get permission from your agent. You can't possess a weapon while you're on probation. You must contact your agent, well, you're already on probation, so stay in touch with all your reporting requirements. You must comply with all the written and verbal orders of your agent. Let the agent into your home at any time. Submit to a search of your person or property without need of a warrant. Report any changes to your agent within 24 hours. You have to have your driver's license suspended for 6 months. You may not drive a motor vehicle while your license is suspended. You must make genuine efforts to find and maintain employment a minimum of 30 hours per week. Sort of sounds like it's therapeutic for you to be employed like you are.
I like it.
I totally
I mean-
agree with that. So keep it up. And Mr. Roper, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. It explains that more on the form that you are now receiving. And that takes us to the other matter, which was the probation violation. And Mr. Roper, you had already pled guilty to that, and then we had put off sentencing a couple of times. And that's right? He pled guilty, yeah.
Yes, Your Honor, I think there was just the one adjournment so
Yeah.
we could have it the same date. but
So
yes,
this is the
correct.
time set for sentencing, and I have Mr. Coker here, because this is an Attorney General case, and Mr. Teetsort. And Mr. Teetsort, I didn't have any written recommendation from you, which is fine. Did you want to make a verbal recommendation? You're muted.
Yes, thank you, Your Honor. I did it that way because the pre-sentence update report, I think, covers most of the important aspects, but I would, well, briefly, I apologize with that report, the initial report, with the family information being wrong. I didn't complete that report, and I do like to review them, but typically I would just trust that as that already appeared before the court, any corrections would have been made.
Sure.
Additionally, because this is a child support case, I think that was the primary focus, and I don't want to say it got entirely overlooked, but the substance abuse issue was not first and foremost, but I think now we're trying to make that first and foremost. He has made some payments, and the Attorney General might be able to address that, but there also was a number of months he's missed paying. Some of those were during the early part of the pandemic, so that might be extenuating circumstances. And lastly, I would just ask for the court to continue this 5-year probation and only modify it by adding in outpatient counseling and drug testing so that that's consistent with the new order. Thank you, Your Honor.
Thank you. And Mr. Coker, did the people want to be heard?
No, Judge, I'll just ask that the court follow the recommendation from probation in this matter.
Okay, thank you. Then, Mr. Roper, I will, consistent with the sentencing on the other matter, just continue your probation, and we will add the outpatient treatment and drug testing. Is that what you said, Mr. Teepsor? Yeah.
Yes, just regular drug alcohol testing. Thank you.
Yep,
I'm already, I've signed myself up already, so,
I'm sure, yeah.
yeah.
Okay, then all your other terms and conditions of probation will continue to apply, and then also on this case, I must tell you, you have the right to file an application for leave to appeal your conviction and your sentence. You're entitled to an attorney at public expense, and if you're making a request for one, you have to make it within 42 days of today's date. And I know it seems silly, but we have to give you 2 forms that are exactly alike. And there you go. You're all set. Continued best to you. Hang in there.
Thanks, Your Honor.
Okay.
Yeah.
Thank you, Your Honor.
Appreciate it.